Today's Brandon blog is titled Four Pillars Class Action Lawsuit Settlement, our definitive guide to the Pearce versus Four Pillars lawsuit settlement. On January 13, 2022, the BC Supreme Court approved an overall settlement administration plan, which consists of several individual settlement agreements. So now the Pearce versus Four Pillars class action litigation in British Columbia comes to an end with this settlement agreement. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. First, we hope that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver, Inc. remains fully operational. Both Brandon Smith and myself are continuing to hold all meetings either by telephone or video. So shoot us a message, give us a phone call if you have any questions at all, either about this Brandon's blog or anything else at all. We would love to hear from you. I hope you can watch this video until the end, because I know you will get value from it. This Brandon's blog, Brandon first goes back to go over what the Four Pillars class action lawsuit was all about. Brandon had previously written two blogs on this issue, one in September 2019, which explained the launching of the lawsuit and seeking certification as a class action lawsuit in the province of British Columbia. And then in May 2021, Brandon wrote a blog discussing the Four Pillars appeal of the lower court decision to the British Columbia Court of Appeal, and the fact that the British Columbia Court of Appeal dismissed the Four Pillars appeal and upheld the class action certification, and that the lawsuit could proceed because the matters alleged could only be decided upon a full trial of all the evidence. Some of the allegations were that people on the brink of insolvency paid Four Pillars unnecessary fees, and that Four Pillars actually violated sections of the Bankruptcy and Insolvency Act, Canada, and that there should be civil damages arising out of that. Brandon goes on to give a review of those two previous blogs just to bring you up to date, and why the Court of Appeal for British Columbia found that the class action waiver clause in every standard contract every one of their clients signed. Brandon then states what the Court of Appeal found the role of Four Pillars actually is, and then why the decision of the appeal court led to Four Pillars class action lawsuit settlement. In his previous 2021 blog, Brandon questioned how this might affect all the different Four Pillars businesses across the rest of Canada, and how Four Pillars certainly cannot let this go to trial. Well, it seems like Four Pillars agreed with that and felt the same way because they reached a settlement rather than going to trial. Now, the settlement means that none of the allegations in the class action lawsuit were actually proven, and Four Pillars is on record as having denied them all. But they reached a settlement and the court approved it. And Brandon then discusses what the settlement is and provides all the details, including the $7 million settlement fund that has been set up to pay the claims of anyone in British Columbia who was a client of Four Pillars and meets the class qualifications. So I hope you will be able to read the entire blog below, because I know you will find it very informative and get value from it. Again, the Ira Smith team hopes that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver Inc. remains fully operational. Both Brandon Smith and myself are holding all meetings either by telephone or video. And if you have any questions at all about this Brandon's blog, about anything bothering you about your financial situation, your company's financial situation, or anything else at all, give us a phone call, shoot us a message. We would love to talk with you.